好，首先
We have a quorum. I call the meeting to order. But I first like to remind you that please occupy your own seat because we may have a bigger group than usual. And I may ask you to press the request to speak button if need be. We'll be going into the agenda soon. Item 1, information papers issued since the last meeting. Ever since the 26th of November, when we had the last meeting, the panel received a total of 6 information papers. The details are in item 1 of the agenda. Please, if you like, make reference to those papers. To save time, I shall not read out those papers. Please go to CB bracket 4, 294.01.03.01, and then 321 bracket 01, and also 337 bracket 01. All those papers are information papers. Item 2, items for discussion at the next meeting. Members, please take a look at CB bracket 4324 stroke 18 to 19 bracket 01. That's the list of outstanding items for discussion. And CB bracket 4323 stroke 18 to 19 bracket 02, the list of follow-up actions. At our meeting on the 28th of January 2019, that is our regular meeting, shall take up 2 issues. 1, review of duty lawyer fees. 2, biannual review of criminal legal aid fees, prosecution fees, and duty lawyer fees. These are the first 2 items in the list of outstanding items. I'd like to ask members whether you agree that we list these 2 items on the agenda for the next meeting. I don't see any objection. Yes? I don't see any objection. We are asking members only. Next, Mr. James Toh, Mr. Ted Ho, and Mr. Lam Chuk Ting wrote in a co-signed letter. And again, James Toh, Ted Ho, and Lam Chuk Ting wrote in on the 13th of December 2018 requesting the panel to call a special meeting so the DOJ can come to give an account on the non-prosecution of CY Leung. I'd like to listen to members' views, as I said, in public. In order to manage the time, I'd like you to raise hands. I have to calculate the time for members and non-members to speak. Can I please ask only members to raise their hands? Members, please. There are quite a few. Let us count how many there are. Just members, please. I have to manage the time. 14 non-members who would like to speak. Seven. Since many members have requested to speak, well, if there were not so many non-members, I tended to be rather relaxed in managing the meeting. But now we have 6 to 7 non-members. I would say that since the 3 members wrote in together, you would have 3 minutes, others 1 minute. And also 1 minute for non-members. Well, I will allow members to finish what they would like to say, but I will not allow as much as 3 minutes. The three of you, the co-signatories of the letter, can have 3 minutes between them. Well, I have to explain that this is a regular meeting, and we have already got 2 items on the agenda. I have already done my best. Since there is so much concern on the issue, and the legal advisor will also be giving a view, so this one will take up 25 to 30 minutes, and that is a long time for issues like this. As long as you have raised your hand, you'll have 1 minute. Now please press the button to speak, but I must say that there will be priority for members. It's very seldom that members are so forthcoming wanting to speak, so I will give the priority to members, and then we will have non-members. Please press the button now. Have you all pressed the request to speak button? I have 19, not including myself. Please go to your own seat. Those who were punctual would know that you should occupy your own seat, the seat assigned to you. Okay, your name has been noted. That's it. I'm drawing a line there. That's all. Since you have been punctual, I will give you a chance to speak. First, I shall ask the 3 proposers to see which one would like to speak, and then the legal advisor will also give us his view. Well, we discussed it, and he said that before other members speak, he would like to update you of the situation. Mr. James Toh, please. The 3 of us will each speak for 1 minute, and I will go first. My proposal is simple. This is an issue of a lot of concern to the community, and the decision not to prosecute has also aroused a lot of concern in the community. If we look at similar incidents in the past, the DOJ would use a long paper to explain the decision. We'd like them also to give a longer explanation, and that was also precedented in this panel. You may call it prosecution policy, and you can use this as an example so the DOJ can explain the reasons. And through their representatives, meaning members here, the community will be able to listen to the Secretary for Justice, the reasons for not prosecuting, and also her considerations. I think that will be the best way to give an account to the community. Next, Mr. Ted Hui. Chairman, I think the S4J should have been here today. There will be no prosecution against C.Y. Leung and Holden Chow. I believe that has shaken the confidence of Hong Kong people in our legal system. It's okay, she is on leave today. I think she is acting in an irresponsible manner, but we should hold a special meeting and invite her to come and explain the non-prosecution decision to the community and to us. We have the Sally Orr incident, the other incidents, including Judge Wong, and we were given all the reasons for non-prosecution. I hope that special meeting can be held at the end of this month or the latest, the beginning of next, so the S4J can explain herself. Next, Lam Cheuk Ting, Chairman. This decision not to prosecute C.Y. Leung has been made by Teresa Zhang, the S4J, and she has flouted the convention of the DOJ by not seeking independent legal opinion. The community is of the view that the DOJ may be biased and there may be conflict of interest. That is the perception of the public, and that perception is going to hurt the confidence of Hong Kong people in our legal system. There will be no prosecution, and that is going to undermine the public's trust in a corruption-free Hong Kong. If the DOJ has strong grounds to support non-prosecution, the S4J should grasp the opportunity to explain to the public, but regrettably, there is only a one-page statement, and half a page has been devoted to all three allegations against C.Y. Leung and Holden Chow, and she's not addressing the queries. Now I hand the floor to the legal advisor. Thank you, Chair. I'm aware that yesterday a citizen has filed an application for leave for judicial review at the High Court against this non-prosecution decision. Well, that is an application for leave. In other words, the judicial process has been kick-started. According to Rule 41(2) of our Rules of Procedure, members should not be mentioning cases which are to be decided upon by the court. And according to Rule 43, this will apply to panels as well. In other words, the chairman can make a decision as to whether this will be out of order because we are attempting to reconsider a specific question which may be decided upon by the court. And as to whether there is enough justification for the decision, I believe members should exercise caution in mentioning those. Well, the legal advisor has issued a reminder and he has updated members of the situation. Now we are opening the floor to members. Dr. Low Wai Kwok. Thank you, Chairman. Earlier on, with regard to Jimmy Lai and 6 others who were suspected to have illegally received political donation or made political donation, well, there was also a decision not to prosecute, and Mr. Junius Ho also questioned that decision here. And at that time, a member also mentioned the UGL case. And at that time, the chairman made a correct decision, in my view, meaning that our panel can discuss the prosecution policy of the DOJ. That is, we are a suitable platform for discussing it, but we should not go into specific cases. Just now, a member said that this case can be an example, but I don't think it is appropriate, especially when the legal advisor said just now that actually this case has now been the subject of a judicial process. So I agree with you, Mr. Chairman, and it is also my view. Ms. Eunice Yong, I'd like to refer to the reasons cited by the co-signatories. They say there is community concern and that the decision is not fully explained. I like to say that according to the Criminal Procedures Ordinance and also the Prosecution Code, the Prosecution Code is very clear that there should be sufficient evidence. You have to comply with 5.4, 5.5. You have to look at the sufficiency of evidence, and then you come to the issue of public interest. In other words, you must satisfy the first leg of the prosecution criterion. Now, people are saying that there is public concern and that they are not explaining the reasons for non-prosecution. But if I look at the DOJ statement, it is very clear. There are 3 crimes or allegations, one, corruption, and then misconduct in public office. I think the statement is quite complete. Ms. Starry Lee, members, we have always, Chairman, we have always said that we should uphold judicial independence. According to Article 63 of the Basic Law, the DOJ should not be interfered with in making prosecution decisions. I believe there is sufficient consideration and has made a professional decision. We should not make use of this platform to interfere with the decisions of the DOJ. I also think what the legal advisor said to be very rational and justified, and there is already a judicial review process, and the DOJ has also said that they would not make any comment because that may impact on the progress of the JR. And 3, I don't think we should break with convention. Panels should discuss policies and not cases. if after the JR is completed, if the DOJ is of the view that there can be some explanation, she can come on a particular occasion. And of course, every one of us has got a position with regard to the UGL incident. And actually, members will not support any explanation because they just want to attack CY Leung further.
Jenkins Paul. Thank you, Chair. Whether there should be a prosecution or not, we would all agree that that would be under the purview of the Secretary for Justice. It is her decision, and it is also up to her whether she wants to seek legal opinion. It is not true that just because the person involved is a person of renown and therefore the Secretary for Justice will have to act one way or the other. And where there is public concern, the Secretary for Justice can provide a written statement. This written statement would be clear enough. Unfortunately, everything is so politicized here. I do not believe that there will be a discussion which will be fair and balanced. So I think we do not need a meeting as such, but the written statement would suffice. Chair, if written statement would suffice, then it should not be a one-page statement, but a multiple-page statement. Even the CE had mentioned, and Chan Chi-si had came out to say, Bernard Chan had also come out to say that there should be more explanation. And I think Teresa Chang should proactively come up to provide more explanation and come to the LegCo as well. I think in the first instance, Teresa Chang should come to the LegCo and to the panel, this particular panel, to explain why there is a non-prosecution for this case, to have a thorough explanation and also to be answering members' questions. It is not an issue whether we invite her or not. Even the CE had, kind of hinted or made it public that she would be happy to come up. Julius Ho, I very much agree with my colleagues just now concerning principles, but on the other hand, the pan-Democrats, they are not abiding by principles. And I have made it very clear in the media as well, TV, etc., Wan Shu Kin, Lam Chek Ting, etc., they have all been alleged to have been contravening the evacuation order. There are over 200 cases still pending for the Occupy Central situation, and there are these under-the-table money collection cases which are also being alleged. So let us prioritize those. Chair, Lam Chek Ting, I thought that this is a learned community of members in this room, so I really do not understand what Julius Ho was referring to. But for this particular case, it is a non-prosecution case as decided by the Secretary for Justice. And I think there should be a square and fair explanation to the people of Hong Kong and education to the people of Hong Kong. Tong Hin Ming was not prosecuted, and there were 6 pages of statement to explain that. And it's only 1 page of statement for CY Leung. He's in such a high place. How can 1 page suffice? Let us all learn what is law here, rather than to have just 1 page of statement. If the CE is saying that it is not problematic to come here, then I think it is rather unfair for the establishment camp to, quote-unquote, protect the Secretary for Justice. Well, Chair, I think we have to go back to our principles. We have always been honoring the principle of non-detailed disclosure for cases, and that is whether there is sufficient evidence and information that can be disclosed, but on the other hand, the details concerning the case need not be made public. Barbara Mills, a Queen's Counsel in the UK, had also made that clear. The public will have the right to know the principles for the prosecution in deciding on whether to prosecute on a case. There should be some high strokes or broad strokes explanation on the grounds of whether there is prosecution or not. But there should not be any disclosure of the details, otherwise of the case. Otherwise, it will become a public trial, and that would not be fair for the person concerned. Mr. Chair, the CE had already mentioned that where necessary, there can be further explanation, and she personally can make that explanation. By so saying, she's prepared to provide more explanation. And the venue can be at the LegCo, and LegCo is not the only venue. It can be outside of the LegCo as well. The legal advisor had mentioned just now that there is a citizen who has lodged a leave for judicial review at the High Court. And we know that there is a standard answer to that, and that is because of a pending case, we cannot discuss the details of the case because of this legal procedure. So I ask, is this the right time to discuss this? Perhaps not. Perhaps we wait for the judgment from the court before we continue further on the case if necessary. Chu Hai-dik. Chair, first of all, colleague Chang Kwok-kwan, I don't know whether he's just arrived in Hong Kong. I wonder why he does not remember Ms. Leung Oi-si, the previous secretary, had explained in detail and discussed in detail her decision not to prosecute Hu Sin. And I remember the time she said that a lot of Singtao newspapers, company employees will lose their job if there is a prosecution against Ms. Hu Sin. And at the time, there were a lot of people who expressed surprise at that explanation. But she's done that, Ms. Leung Oi-si, providing that detailed explanation. But on the other hand, we heard that this one-page statement from Teresa Chang is clear, but it says that I do not understand why this one-page statement suffices in saying that C.Y. Leung is guilt-free. I cannot see that. Kwok Wing-hung. Chair, I really don't understand. I remember last time, a lot of the DAB members had questioned why the Secretary, Teresa Chang, did not come to the LegCo, and she did not have a position or a stance, and they criticized her for that. And now the DAB is saying that she need not come to the LegCo. And now I understand why. Because this has to do with the DAB member, Mr. Holden Chow, having certain dealings with, secret dealings with C.Y. Leung. When it comes to other issues where the secretary is not providing explanations or not coming to the LegCo, the DAB would criticize that. But because this particular case pertains to their own member, and that's why they are protecting the secretary, so to speak. Fernando Zhang. Chair, this is, someone said that this is interference of the secretary's decision on criminal prosecutions. But actually, what we're asking for is a case which has high public ramifications and impact. It is a responsibility of the Secretary for Justice to come here to explain to us the decision. The decision has already been made. There is no interference from any one of us or from the LegCo to speak of, because the decision had been made. There is no interference to the independence of the Secretary for Justice in making the decision. I think this is the right to know for the public. She should come up to explain to us. Now, the non-members will speak after the members. So next, Lam Kin Fong, please. Chair, Article 63 of the Basic Law is very clear in saying that the Department of Justice of the Hong Kong SAR shall control criminal prosecutions free from any interference. And just now, Lower Kwok had mentioned very clearly whether the cases are suitable for discussion here at this panel or at the LegCo. I will not repeat the point here. There had been other cases which had been discussed at the LegCo. The opposition party, their stance then and now are completely different. And for this case, there is already an appeal being applied for, actually applying for leave for judicial review. All the more, given that we should not discuss this case here. And even if the Secretary for Justice appear at this LegCo, it is a waste of time because she would not be able to disclose anything. Therefore, I'm of the opinion that we should not invite the Secretary for Justice to come here. Ho Kai-ming. Thank you, Chair. I've looked at the letter from Lam Cheuk-ting and James To. I think it is not just for this case that there should be explanation. Why would the Oriental Daily journalist why was there no prosecution for that case? What about Jimmy Lai collecting black money? Why was there no prosecution? Why did the Secretary for Justice did not come to the LegCo to explain the decision on those cases? At the end of the day, the decision rests with the Secretary for Justice. So I do not see any reason summoning the Secretary for Justice to the LegCo for explanation. In their letter, it says that there is no sufficient evidence for making the non-prosecution decision. I mean, this is a ordinary legal principle on evidence-based prosecution, and I find that letter of theirs very, very curious indeed. Mark Mei-Kyun. Chair, this is very straightforward. Asking the Secretary for Justice to come to the LegCo is really for political reasons only, and that is to continue with the discussion on the case continually and incessantly. To use the LegCo time to do political shows is totally unnecessary. We should use our time to really discuss things of substance. Now you're summoning the Secretary for Justice concerning non-prosecution decision. As Mr. Ho had mentioned, what about the Oriental Daily journalist non-prosecution? If you look at the Oriental Daily newspaper every day, you see this being reported every day, and people are concerned. The public are concerned about that. Let's drop all this political posturing and show, please. And perhaps they have to play their own constituency, but please don't waste any more of LegCo's time. Chair, at the time, the opposition, when Mr. C.Y. Leung was CE, they wanted to have political shows in attacking C.Y. Leung. But now that C.Y. Leung has already stepped down, to continue with this kind of play is really wasting everybody's time, including the LegCo's time. And I'm sure there were other people concerned. I mean, for the two sides of the case, it is taxpayers' money which had been used. So why do we want to waste the public resources even further by wasting the time of the LegCo, continue to divide Hong Kong, continue to waste the resources of the Hong Kong people? It is not worth it. Cheung Wah-Fung. Chair, I think the Secretary for Justice has made it very clear in the statement that there is insufficient grounds for follow-up on the UGL case. But it is the opposition party who would want to further attack C.Y. Leung and also to attack his good name. What we need to rely on is facts, and they are putting their own preconceived opinion on the trial. The trial is already, there is already a decision made on the non-prosecution of the case. The non-prosecution of CY Leung on the UGL case, for there to be continual criticism and discussion, is really to destroy public order. That's all I want to say. Madam Chair, the Secretary has used just one page on a 4-year-long deliberation on this particular case, and then she is not appearing in front of the public and the LegCo. I mean, corruption is a very serious offense. Cannot the Secretary just tell us in very straightforward terms why there is no prosecution? What is a political show? Because CY Leung is the China Consultation Committee deputy chair. That's why there is a protection for him.
We are asking her to come here. If she had acted in a fair manner, why should she fear? We are not going to eat her up. There would be security guards all around her, and we are just asking her to speak up. Mr. Shukafai, thank you, Chair. Just like the case of Jimmy Lai, non-establishment camp members thought that she needed not come, but this time around it is CY Leung, and now the establishment camp are saying that she needed not come. Well, both are legal cases. We have judicial independence, and whatever belongs to the court should be left to the court. And we are a legislature. We should be legislating, and we should not be delving into political cases. Our own legal advisor has reminded us that there is now a judicial review case underway. Even if we ask the S4J to come, she will not be able to speak up, and then it will amount to a waste of counsel time. I would say that we refer law cases to the legal sector, and we should concentrate on our own legislative affairs. Cheng Chung Tai, I believe the S4J should come here to convince Hong Kong people that the DOJ knows the law for Hong Kong people. There is a point saying that CY Leung has no conflict of interest, and therefore there was no legal requirement for him to make declaration, and that it did not constitute any MIPO offense. That has distorted our understanding of the declaration of interest system. If there is no conflict, there needed not be declaration. Is that really the case? Does that apply to LegCo? We want her to tell Hong Kong people whether our understanding of the declaration of interest system still holds. And also, this has something to do with the future amendment to the Prevention of Bribery Ordinance. She has to explain to us why the CE can occupy a particular position above the law. Is it really because there is no sufficient evidence, or was that a sole decision by the S4J? The public has a right to know. Wong Kwok Kin, Chairman, all in all, I heard the opposition party complaining of the lack of information. Well, this is all because there is insufficient evidence. It's as simple as that. Don't you have brains? This has taken 4 years. If there has been any new information, it would have come forward. The select committee here has spent over 2 years, and there is no progress. We can't even have meetings. Mr. Lam Cheuk Ting and his party friend went to the UK and Australia, and they could not dig up new information. And that goes to show that up to this moment, we have no sufficient evidence, and therefore there is no query that is possible for the S4J's decision. If you are compelling the S4J to prosecute people, are you actually making political persecution on somebody? Given this political environment, it is not strange for us to have that kind of suspicion. Okay, it's now my turn. I'd like to speak on behalf of the panel and how this was handled by the panel. Some members have requested to do something about a non-prosecution decision of the S4J, and this is not a single incident. In 2015, 2016, 2017, and 2018, if you read our minutes, you would know that January, February, July, you have all the information in our minutes. There were different cases. the occupied central people who started the movement, they were not prosecuted, and also this case, this time, and also in recent times, Mr. Junius Ho mentioned this year, and this was for reference, on the 26th of February this year, we were handling a similar case. He asked for a special meeting, and that was about Jimmy Lai, whether he would be prosecuted. At the panel here, we had a discussion. In fact, we hold a discussion every time. The way it was handled was that, as I told you about 2015, 2016, etc., we would put these on the agenda. We would call it the rule of law, because there were too many members who would like to raise an agenda item on the areas of their own concern. And I'm talking about members of the entire spectrum. And you remember this year we handled Mr. Junius Ho's request, and we said we should only be looking at policies, meaning the prosecution policy. You can read the minutes, and if you know how to pose questions, you would be able to go at the principles, whether the opposition camp, the establishment camp, both asked questions, and people were talking about Franklin Chu as well. And there were many such cases, and therefore we have to be consistent and fair. If you look at our meeting minutes, you will know that members of the entire political spectrum have said that we can discuss the prosecution policy, and we agree that this will be listed in our list of outstanding items. And now this is number 16, and we can invite the S4J on a suitable occasion to come here. Since there are so many members this time around that you would like to discuss the prosecution policy again, since I want to be consistent, starting from Wong Kwok Heng, many members asked the S4J to come and explain herself. And indeed, our panel should not be debating cases, especially the legal advisor had actually asked to be given the chance to speak first, and actually I had wanted him to speak last because he said that he would like to give his legal advice to members at the beginning. So first of all, it is not that I have an assignment. I would, of course, not receive any assignments, say, about Jimmy Lai's non-prosecution decision. In fact, no matter whether it's any member who is making the request, I have done the same thing. So in the circumstance, I hope we need not put this to a vote, because I have to give consideration to the legal advice I was given. If you would agree, members, I would propose that at our next meeting, in our regular meeting on the 28th of January, since the two items proposed are not going to be substantial, we can discuss the prosecution policy. So you can also discuss the rule of law, and we can do the same thing because we did that in 2015, 2016, 2017, and 2018. And this is nothing new. Well, you can say that this case is about huge public interest. And in fact, even establishment camp members have said that things are of public interest. So we can discuss the prosecution policy here at the panel, instead of taking up certain cases as raised by members. Please refer to the minutes of the February meeting. For example, in paragraph 14, 15, in response to Mr. Junius Ho, we talked about the farming out system. And in fact, even the Jimmy Lai case was not the subject of seeking external legal opinion. Therefore, we can speak on the prosecution policy. If you think this is okay, we do not need to put this to the vote, and we can do the liaison work to see whether this can be arranged. So we do not need to hold a special meeting. Now here, only members can vote and can comment on this proposal of mine. Well, I would say that this is already the best, the most proper way to deal with it, considering the legal advice of our advisor. And in fact, we have read through the previous meeting records. And in fact, I cannot remember what every member said on those occasions, but I have looked at the minutes. I think this is the more proper way of doing it. And in fact, the judicial review case will come to a close. And at this time, if you invite the S4J to come And I don't think you would be told a lot. I don't want to dwell on time management too much. I hope we do not need to take this to the vote. As you know, if you vote on it, this will be put on the back burner. And if you think it is not necessary to take a vote, this is the way I propose to handle it. I am only inviting members to comment on this proposal because after all, it's only members who can vote. I know I don't have the voting right, but I can please speak briefly, Chair? No, I don't think so. Sorry. I have promised that we should start the next item by 5:10. If we don't need a vote, we can save some time. Maybe you can ask James Toh, who is a member, to speak. I would only give the time to members. Members have that right to speak at this panel. James Toh. Chairman, at the beginning I said that I would like to give an opportunity for the S4J to come because even the CE said that she could explain. And I believe if she comes, she will know what to say and what not to say, and safeguarding her role by way of prosecution under the Constitution. I hope she can be invited to come under the subject you proposed. I certainly welcome the S4J at this panel. As I said, I tried to liaise with her, but I failed. We will again issue an invitation to the S4J, and if we have an item on the agenda, I hope she can come. Of course, she needs not choose this panel to speak. She can speak in public, just like other directors of bureaus. She can give a detailed explanation on whatever occasion she chooses. But this is not directly related to this panel. We, as a panel, can only act according to convention. Mr. Paul Chan, your analysis and summary, Chairman, given the multifarious views expressed, and some, of course, were not in line with the panel's convention that we should not discuss cases and only policies. I think you did the right thing. And to be fair, different people are mentioning different things about different cases. However, allow me to make one point. I don't think we should only ask the S4J to come, but also the public prosecutor, because the DPP, Deputy Public Prosecutor, was already appointed to handle the case. That was done by the previous S4J, and I don't know why the incumbent S4J has made that decision herself. I'd like to hear from her. Thank you, Mr. Paul Chan. From the records of our meetings, apart from the S4J, the DPP also attended our meetings when there were matters of huge concern amongst members. If you read the minutes and if you know how to pose questions, you will be able to go at the principles. Lastly, Ted Hui. We can only allow members to speak. Ted Hui, the last speaker. Chairman. This case has aroused a lot of concern and it has shaken the public's confidence in the rule of law, but she is on leave. And Chairman, you are saying we should wait for another month to invite her to come. I don't think that is appropriate. I mentioned the Sally Orr case, Anthony Leung case, and Judge Wong Kin Chow, and we devoted a meeting to one case, and now you are postponing it to the next month, and it will only be one item for that meeting. I don't think it is appropriate. As you know, justice delayed is justice denied. I hope you will hold a special meeting as soon as possible. Okay, thank you. That's all for members. You said that the case has aroused a lot of concern, but in fact, in recent years, well, I can tell you, it happened every year. Different members had talked about the prosecution policy because there were cases relating to people they did not like. And that started from 2015, ever since the Occupied Central movement. There were many cases. Now, you say this case is of particular concern, but then all the other cases also related to very famous people in our community. So I won't put this to a vote. I will handle it as I proposed. If you wish to put it to a vote, well, that is only a view for my consideration. I don't mind putting this to a vote, but then I would only regard this as something for my consideration. I think I had done my very best. If you would like to put it to a vote and this is vetoed, it would not be listed in the agenda for the next meeting. If you don't accept my proposal, I will have to do that because I have already given you an opportunity not to put this to the vote. I can foresee the results of a voting exercise. You can see that too. I am saying that I would like you to have an opportunity to speak on the prosecution policy, and that would be my decision. So that's it.
So this is the best way forward. And I have already talked to the legal advisor and also the secretary to see whether we can, at our next regular meeting next month, and to have the secretary to talk about the principle of prosecution or the public prosecutor to come up. And I think that's all the different parties are of the same view. And so I think you would all be able to see that we have done our best to arrange for this. And you will all see the situation. Next, let us go to our agenda for the meeting. And this is to visit the judicial institutions. Now, we have visited as a panel to the judicial institutions, including the High Court, and also held exchanges with the personnel. And I have agreed that on the 21st of May 2019 a.m. to visit the judicial institution and to exchange views with their personnel. Would members please allow time for that visit, please? Actually, we do this every year. Do you all agree that we invite members outside of this panel to join that visit, please? If you have no opposition, then I would send an invitation letter to all. And further, we will discuss with the concerning arrangements with the judicial institutions, and then we will inform members. Next, let us go into the agenda, which is the proposed creation of one permanent post of Principal Government Counsel, one permanent post of Deputy Principal Government Counsel, one supernumerary post of Deputy Principal Government Counsel, and upgrading of one Assistant Principal Government Counsel post to Deputy Principal Government Counsel in the Department of Justice. And the paper is CB4 3231819-03. Yes, the administration is settling down, and would you please bring us through the paper, please? And members, if you want to speak, would you please press the button? Mr. Siu, would you want to bring us through the paper? Yes. This is concerning the proposal for certain posts to be created. First of all, we want to have a DL3 permanent post created for Principal Government Counsel and the Secretary for Justice's Office to strengthen support in enhancing Hong Kong's role as an ideal hub for deal-making and leading center for international legal and dispute resolution services in Asia-Pacific region. Because we see in terms of arbitration competition in the nearby areas, there is a very high heating up of such competition, and there is a risk that we will lose this competitive edge. And lately, there is a survey conducted by Queen Mary University of London, the International Arbitrary Survey. Hong Kong has dropped out of the top 3 most preferred seats of arbitration in 2018, and we are number 4 in that survey. To us, this is an alarm bell. So, in terms of arbitration development, we need more promotion, and we need a long-term strategy so that we will have the long-term effect so that we can be we'll have a comprehensive and long-term strategy to promote our resolution and dispute services, and in particular with the Belt and Road region and the Bigger Bay area opportunities. We want to be able to grasp those opportunities, and we would want to recover lost grounds. And further, we would want to set up a center and also a platform for arbitration and resolution of disputes, and also a investment arbitration course to be set up so that we can train up a team which will serve this purpose in Hong Kong. And also we would want to have a platform for e-contract and also for online resolution to provide services to the sector, and also for the Greater Bay Area to provide this service for disputes resolution, and also to provide Hong Kong as a capacity building center as well. And also we want to host big international legal events. For example, in 2022, we have been able to successfully be the host for a very large-scale international legal services conference in Hong Kong, and that is very good. And we also want to set up an office which will coordinate all the dispute resolution services in Hong Kong, and also to formulate long-term strategy. And we will have this permanent post in the office of the Secretary for Justice to assist her in the work in this regard. And also for the Law Reform Commission Secretariat, we want to create one permanent post of Deputy Principal Government Counsel to strengthen the legal support provided to LRC. There had been over 20 years where the LRC Secretariat had not been added to its personnel except for a DL2 and DL3 posts, but we see that there's been a lot more work to the Law Reform Commission, and the LRC had also reviewed its operation. They want to increase their efficiency, and the structure of the LRC Secretariat is to be intact, but on the other hand, they want to strengthen the legal support from the Secretariat. And the panel have had discussions before, and there had been support for the strengthening of this work. So how do we put this into place? First of all, we will be setting up a small group to review the project, and also we will be setting up 2 joint secretaries. With this mode, we are actually following the UK model, so that the Law Reform Commission and its report, there can be sufficient support for that work, and there will be expert support for that work as well. And further, we would want to create a from D1 to D2 position, and open up a D2 position that is supernumerary position, and a D2 position. And this is because there had been more complex and bigger workload, and members would know that this is because of the increasing cases of claims of repatriation, etc. And also there had been other increase in cases of judicial review, and also there had been other repatriation of personnel, as well as the firewall work. And further, in the drafting of ordinances, and also at the LegCo, there had been a drafting committee which had been set up. We will be conducting other work pertaining to the mainland as well, including where there is coordination between the two areas for legal work, especially in marital decisions and also mutual recognition and execution of judgments, etc. We would want to be able to, as soon as possible, bring on the draft bill and to extend the Hong Kong and mainland mutual recognition and execution of judgments, and also to help cross-border receivership and cases. And we would want to increase the personnel for the the jury system and also class act cases, etc. A number of such additional areas of workload. For this reason, we would want to increase this, create this post of DPGC. Thank you very much, Mr. Siu. Others from the administration, will you be supplementing? They will be helping to answer questions. All right. At present, we have 2 members who have requested to speak, 5 minutes each. I have also pressed the button to speak. Mr. Kwok first. I've just returned, Chair, from the U.S. While I was in New York, I visited with the American Arbitration Association. They told me that they completely do not know what's happening in Hong Kong or what we're doing. Rather, in Singapore, they have an office, and the Singaporean government had been very proactively inviting them to set up an office in Singapore. And after that, there had been cases which had been deliberated in Singapore. And I asked whether they knew that we will be building up our international arbitration center to build up Hong Kong as an arbitration hub, and they did not know about all that. And so this all reflects the fact that we are very insufficient in our work outside of Hong Kong. And Singapore, not only do they act fast, but also they are very flexible in inviting overseas arbitration bodies to set up offices in Singapore and also to start up new arbitration cases. I want to use this as an example or a case to ask a question. Let's say for AAA, every year they have billions or hundreds of billions of arbitration cases in monetary terms. And for major cases such as energy, technology, or commercial, very often it is related to Asian companies or mainland China companies. And very often they need an office or a site in Asia to conduct the arbitration. So how does Hong Kong attract them to come to Hong Kong? And even with these positions created, what would they be doing? Thank you very much, Mr. Kwok, for the questions. Whether it is in Hong Kong or outside of Hong Kong, our other competitors, we are all putting in a lot of efforts to promote ourselves in dispute resolution. In terms of coverage and focus, of course, it may not all be the same between us and them. Over the past many years, our work had successfully attracted international or regional arbitration bodies and other dispute resolution bodies to set up offices in Hong Kong. And before this time, we have already announced our first stage of hub building, and there are 17 of such arbitration bodies. Many of them are international arbitration bodies, dispute resolution bodies, and also research bodies which will be setting up shop in Hong Kong. But of course, around the world, there are many such bodies as well, some being regional, some are local, some are national in nature. We will pay attention to them all. And we exactly need the resources and the manpower to more effectively promote Hong Kong to the world arena and put us up to the highest spot in face of fierce competition and the overall environment. It is exactly because of this and in face of challenge that we need to strengthen our resources. And it is for this reason that we want to be able to get your support in the creation of these permanent posts. There is something which is very important, and the present government, based on the work that we have done before, and we want to do even better work, and that is by providing more manpower. As Mr. Siu had pointed out just now, we would want to have more synergistic effect in dispute resolution and arbitration and mediation. We would want to be able to promote all these at the same time rather than to single out arbitration or mediation.
There is one more point which is also very important. In the process of promoting this, we'd like to provide the S4J with more assistance. Our work is not going to stop. We, as we said, have been able to secure the hosting of the ACA conference, which is an important, very important arbitration conference that will be held in Hong Kong in 2022. We did not succeed the first time, but we have been able to do it this time, and I believe this is very encouraging. As I said, apart from dispute resolution, Mr. Siu mentioned that in the deal-making area, well, the S4J would really like to focus on this so that Hong Kong will have a heightened status in terms of international mediation and arbitration. This is because we want to start at the source. When contracts are negotiated, the parties can already start to think about using Hong Kong law or choosing Hong Kong as the dispute resolution place. And we would need to provide manpower for this. And because of this, we are making this proposal for funding support. Thank you. Next, Dr. Loy Kwok. Thank you, Chair. In principle, I support the proposals for creating these posts, especially the creation of one permanent post of PGC to enhance Hong Kong as an ideal hub for deal-making and a leading center for international legal and dispute resolution services in the Asia-Pacific region. I particularly support this one. In March, at the CPPCC meeting, I raised the issue of making Hong Kong an international arbitration center for the Belt and Road Initiative. In Hong Kong, we have the history and we have an internationally recognized status. And in fact, talking about arbitration, we are not only talking about the legal profession, we are talking about surveying, construction, and even the accounting profession. Hong Kong has got a very good framework and structure, dovetailing our professionals with the international systems. If we look at cities around the world, we don't have many cities where we have got where there is this international status and total dovetailing with international systems. I heard that recently we have come down to 4th in the Queen Mary University of London survey. That makes me worried. I'd like to ask whether there is analysis done as to why we have fallen in the ranking. What are our advantages and disadvantages? How can we boost our advantages and how can we remedy our disadvantages? Mr. Wesley Wong. Thank you, Chair. I'd like to thank Dr. Low for supporting us. Indeed, with regard to the Queen Mary University of London survey, in 2015, we were ranked one of the top 5. In fact, one of the top 3rd. That was the first time we were there. And in 2018, we fell by 1 place and we are ranked 4th. We are paying attention to that. But it doesn't mean that we have performed worse. We understand we need to make progress. And indeed, we did some analysis and we also studied into the survey methodology. And we think that perception is what matters. If someone wants to choose Hong Kong law or Hong Kong's dispute resolution services, they will try to see what other people are saying about this and Hong Kong's reputation and also their own perception of Hong Kong. We understand that we need to work more on this front. We need to do promotion on different levels, at different places. We have to improve people's perception of Hong Kong. So it is not just for us to do a good job. You have to let people know that you are doing a good job. And we are going to put in more resources to do this. Dr. Low, you mentioned the Belt and Road Initiative. We are not only looking at BNR. We'd like to provide a neutral platform which is going to be comprehensive. We hope that international and regional dispute resolution and legal services requirements can also be met by Hong Kong. And we'd like to enhance our own status in this regard. Actually, Dr. James Deng, who is also here, has done a lot. Within the DOJ, apart from the Legal Policy Division, the Civil Division, and the International Law Division have done a lot. At APAC and other platforms, we have done a lot. And I'm not only talking about Hong Kong, but also on the mainland and internationally. We hope that by creating this Deputy Principal Government Council, D3 post, we can enhance the synergy effect. And in future, when we enhance Hong Kong's reputation, we can do even better. Thank you. Thank you, Solicitor General. Now it's my turn. I'd like to ask 2 questions. Number 1, in terms of the Principal Government Council in the Policy Affairs Subdivision of the Legal Policy Division, do you require a condition, meaning that that person has to know international law, international affairs? Because as you know, when we talk about BNR, you are talking about dispute resolution for different jurisdictions. There may be litigation, there may be mediation and arbitration. So first, I'm asking you this question. Who are you looking for and what conditions this person should meet? Secondly, with regard to the Secretariat of the LRC, you are going to create a permanent post of Deputy Principal Government Counsel. As you know, the world is changing. We have artificial intelligence and everything is done online. And as you know, there has been so much leaking of information online. Would the person holding this post be able to contribute to existing laws by updating them? I mentioned subjects that have already been followed up, like the records law, archive law, and class action. But since times are changing fast, people who you are going to recruit should in fact have a different mindset and should have the right knowledge and the right kind of sensitivity so that Hong Kong laws can keep up with changes in the world. Thank you, Chair. About your first question, your observation is really important. We are talking about international legal services and dispute resolution. We are not only talking about Hong Kong laws. If we talk about our country, now, there are already differences between mainland laws and Hong Kong laws. And over and above this, we may have cross-jurisdiction and cross-boundary legal issues. And we have to work on this front. And I'm not only talking about the contract law. And within it, we have investment laws. And also under dispute resolution, you can have different modes of dispute resolution. And indeed, we need to do better coordination in this regard. Within the DOJ, at the Legal Policy Division and the Civil Law Division and also International Law Division, we have different people looking at different legal issues. And yet we need to do coordination. And we need to provide the right assistance to the S4J. And that is why we'd like to create this post of Principal Government Counsel. As for your second question, I was talking about AI. The Secretariat of the Law Reform Commission and assistance to it and services. For the LLC, given the mode of work in Hong Kong, the members are not salaried or full-time members. Because of this, the assistance and service of the Secretariat matters very much, whether it is AI or other aspects of social development apart from technology. Now, if the laws have to be updated and should keep up with the times, and we should not only be talking about increasing the directorate officers. In fact, we also need to increase manpower in the non-directorate ranks. Within the directorate, we have not increased any manpower over the past 20 years. So in our establishment, we have more people providing support services. But in terms of management, we only have Peter Wong, the secretary, and also the deputy secretary for the Law Reform Commission. Now, we'd like to have one more post of Deputy Principal Government Counsel so that we can have one more Deputy Secretary for the LLC, so that there can be coordination and also the monitoring of quality. And there could be some leadership for the non-directorate solicitors. We hope this will be one way to resolve the problem. Okay, Mr. Junius Ho. Chair, basically I support the creation of these posts. If you need more manpower, you should add to your establishment, and if there is surplus, you should delete those posts. And in this paper, you are talking about adjusting the posts. You are creating one principal, and you are adding 3 deputy principal, and you are deleting 1 assistant post. In the annex, in the chart, Annex 2, please. The PGC, Principal Government Counsel, he will work directly to the S4J, and he will be looking at the civil division, the international law division, and also the international organization and legal cooperation. Mr. Wesley Wong, you are the Solicitor General. Mr. Ding is the law officer at international law. And you have Clifford Tefras as the law officer for civil law. So the three of you head the divisions. In fact, you are all subordinates to the S4J. If you need to communicate with the S4J in those three areas, is it that you cannot find the time to do it so that you need another post of PGC to look at these three areas? Does it mean that the three of you will be duplicated in your work? I'm not sure about that. You have shown us the chart, but I don't know about the logic, because the three of you should be assisting the S4J, but now you are creating this post and you are combining the three functions.
So will you have to be discussing with the Secretary for Justice? And if so, will there be overlap of work? I just want to know about that. Yes, who will answer this question? Mr. Wong, perhaps? Well, I want to thank Mr. Junius Ho for his question and his support given to us. In setting up this post, how do we arrange for the work? At present, the three areas, as mentioned by Mr. Ho, the actual work is taken up by the three different officers and the colleagues in the offices. The leaders of these officers not only take up work in these three areas, there's other work for going out to look into these issues in coordination. For instance, the coordination work is not best done because the different officers are concerned, that is, cross-office functions and duties are concerned, and therefore, as we create this new permanent post, there will be coordination work that he can do so that he can assist the Secretary for Justice to coordinate the work of the three different officers so that there will be better coordination, there will be better information flow, and hopefully the efficiency and effectiveness will also be enhanced. So we believe that this will be a step up, an improvement from the structure that we have now. Even though in 2016, in September of 2016, we have already set up a coordination office, and we have provided for a head of that coordination office, but that is not the ideal situation. We hope that with this new permanent post created, the post would not only be coordinating the work of legal policy and also civil law officers, but also where there are work coming from the International Law Office, there can be coordination among these three, all three of them as well. This is the reason why we want to set up this, create this position and to set up this office. All right, this is a second round, 2 minutes each. Lo Wai Kwok. Thank you, Chair. Mr. Wong, just now, in answering my question, he was very clear and accurate in saying whether Hong Kong can serve as the dispute resolution center, and it all is based on public perception or outside perception of Hong Kong. For major infrastructure project contracts, etc., it is true that it would be specified in the contract what the seat of arbitration would be should there be disputes. And if the first instance of the seat of arbitration is not Hong Kong, then it would be elsewhere. So I just want to ask, what is our promotion network in promoting Hong Kong? We have TDC, the ETOs. I do not know whether you have your own network as well. I think everybody will have to pitch in to promote Hong Kong as an arbitration and dispute resolution center. We want to change outside perception of Hong Kong. Thank you very much, Mr. Low, for the question. It's very true what you said. We have to use all our resources and our network. Apart from the ETOs, we have also worked with Hong Kong Investment Promotion Office and also the TDC. We also work with them as well. And also, what we have strengthened in our work is to work with international organizations, including the UN, and also APEC organizations. We're also working with them as well. And in Hong Kong, we have also organized a number of international conferences, bringing world-renowned individuals to Hong Kong to speak and to participate in these conferences. An important one would be the New York Convention 60th anniversary in September of this year. We have hosted in Hong Kong an international conference. And as Mr. Low mentioned just now, when people think of dispute resolution, people should first think of Hong Kong. That is our objective, our goal. And we are focusing on that work. Now, I have to say, I'm always happy that you come to us for creating more posts. I think you should have more people. And to create different posts in the different areas means that you are moving, you are working, and therefore this is a good thing. And so there is a number of areas of work that you seem to be strengthening with the creation of these posts. So first of all, I'm in support of the creation of these posts. And secondly, if you can be brave in thinking of your work and the extension of your work and not be hindered by lack of manpower or resources. I think that is important in legal policy and also the legal profession and our standing in the worldwide arena. That is my opinion. Anything else? I don't think you need to respond on that opinion of mine. Well, I just want to say I want to appreciate the chair's support. It is very encouraging for us. Very good. In that case, we have the next agenda item. First of all, I will have to ask whether members are in support of the proposed creation of the posts from the Justice and Legal Services. Yes, in support. Very good. Next, we will have the administration come into the lecture room. I just want to announce that we need to extend this meeting for at least 15 minutes. And because there are people coming into this room and because these are issues that we have been concerned about for some time, so I would want members to speak up as much as you can. Yes. We have Professor Chiu Wan from the Hong Kong University, Professor Zhao Yun, Head of Department of Law, Faculty of Law of the Hong Kong U, and also Paul Mitchard, Director of Career Planning and Professionalism, the CUHK. Thank you. First of all, Mr. Mitchard, you're free to use the simultaneous interpretation. Put on your earphone. Now, would you please limit yourself to either Chinese or English when you speak, and all your submissions and what you say in this LegCo room will not be protected by the privilege ordinance of the LegCo. And if you have written submissions, you can submit those after the session as well. Now, first of all, from the Judiciary Administrator, who will bring us through the paper, please? Would it be Ms. Emma Lau? Yes, thank you. According to the request from the panel, we have provided some background information concerning employment opportunities and system in the judiciary for legal practitioners and law students. In the paper, we have already clearly set out everything. Perhaps I'll just briefly mention a couple of points here. First of all, for the judiciary, for the practitioners and also the judges, the appointments are made through open recruitment exercises. And these are the system and also the recruitment requirement, etc., are all set out in the paper, so I will not go through the details here. I'm sure that we have already discussed this many times, this issue, and also this is already in the paper. First of all, I just want to point out that it is made through open recruitment exercises. In the past years, the exercises have been openly made, even though there were internal regrading, but there were also recruitment from outside. And also the CFA judge had always emphasized that the highest standards in the judiciary is to be upheld, and that is important to maintain. And also, we would also engage through short-term basis, appoint temporary judicial manpower. In the paper, we have also set out very clearly the details of that arrangement. I just want to highlight one point, and that is with the engagement of temporary judicial manpower, there are two main objectives. One, it is to help the judiciary and the law courts in their work, and at the same time to provide opportunities for those who are interested to understand more deeply, and or especially for those who are suitable for judicial career, to have this kind of short-term, temporary judicial positions. And also in the past 10 years or so, there had been some new measures and items where there are professionals and also law students recruited, in particular for the scheme on judicial assistance for the Court of Final Appeal. I think we have discussed this many times in this panel at the meetings, and this scheme had been ongoing for a number of years. It is very successful and it will be ongoing. And the Court of Final Appeal judicial assistance positions are filled by law students, and it is filled for about a year. And after that, the law students will continue to develop in their own chosen area. And at the CFA, they provide research on law points and also assist in other work of the highest level of court and assisting the judge in the cases before the court. And in the High Court, there are also judicial assistants as well. Their work would be to participate in assisting the judge in the actual preparation of the case and also research into the case. And such judicial associates for the High Court consist of two streams. One is to assist in civil cases and legal research work, and the other is to provide assistance in hearing of criminal appeals. Again, this scheme had been in place for a number of years. We feel that it is highly satisfactory, and we have open recruitment from time to time. And for the judicial associates for the High Court, we require longer post-qualification experience. And further, with the judicial institutes, we also have professional staff for the executive body of these institutes. And this is to support and to assist the training and nurturing of judicial personnel. So, Chair, it is really three parts: a substantive personnel appointment, temporary appointment, and other non-judicial personnel, but really assistants and associates supporting the work of the courts in these three areas. This is what we provide in terms of the employment opportunities and system in the judiciary.
I will pause here and I will be happy to take questions. Thank you. Thank you, Ms. Lau.
Paul Richard.
Yes, hello.
Thank you.
I'm here on my own. Professor Zhao from Hong Kong, you apologizes he had to leave, but he did discuss with me before he left his views, and he also reflects the views, I understand, of his counterpart, our counterpart at the City University, with whom he has discussed this. And I think that really assuming this is working, and you're saying it is working, and you are presumably getting quality candidates, I think there's not a lot we can actually add to this. If you were having difficulty recruiting good people for these positions, I think the law faculties in Hong Kong would have an active role in trying to redress that. But assuming that that it's working, there isn't a lot we can say. I think one point of information is on the what you call the JDA scheme, which is for the judicial assistants. It's not. It seems from this that you don't require qualification as a solicitor or a barrister. Is that correct? That it's just the degree and the PCLL rather, which is enough. Is that correct?
Ms. Lau? Thank you, Chair. Thank you for the question. With regard to judicial assistance for the Court of Final Appeal, they only need to have an LLB degree, and then they need the PCLL, or within a particular time they should obtain a PCLL, because the JDA for the CFA is devoted to fresh graduates who will be able to join the CFA to assist judges by providing research assistance. Usually, the contract is for 1 year. Every year, we are going to recruit new JDAs. We believe the system has been with us for a number of years, and for the court, we know that the JDAs are found to be very good, and the system is functioning satisfactorily.
Comment to add, Mr. Paul Richard?
No, in light of that answer, we have a number of, I'm sure the other law faculties do, we have a number of students every year who, for one reason or another, don't get a position in a law firm or a barrister's chambers, and for one reason or another, maybe there's been some interruption in their education or whatever, and they're looking for a role like this. I guess, as I said before, if you feel you're getting good enough quality people, and it does sound as if the answer to that is you are, then there is nothing really we need to do or say, because we've got people. I guess the other question is about the advertising of these posts. It's difficult for us. The other two faculties don't have a dedicated career expert as COHK does, but it is difficult enough even for me, who am full-time dealing with careers. It's difficult to locate these various job opportunities, to let students be aware of them. And it would be helpful if you, I don't think you do at the moment, it would be helpful, and the same is true of other government positions, if, when these are coming up for renewal, you could let us know and remind us, because I can't keep looking at all the different websites that I have to look at. And I think that would be an advantage for you, because it would increase the likelihood of getting top quality candidates.
Ms. Lau, Chairman, thank you for the question and the comment. On the JDA scheme of the CFA, every year before we put up a recruitment advertisement, we do write to the 3 schools of law to tell them that an advertisement will soon appear, and so that they can alert their students. In all these years, the experience is that we receive a lot of applications. As I said, we do see a lot of interest, and competition is quite fierce. We have had no difficulty in selecting suitable people to take up these posts.
發問嘅時間，第一位呢
Now members can ask questions. The first one, Dennis Kwok, 5 minutes each. Thank you, Chair. The legal sector has always supported the schemes of judicial assistants and judicial associates. But we think there is room for increasing the numbers, especially at the High Court. There are now 12. You will engage 2 more, so 14 in all. But if you look at the High Court, if you look at the number of judges, and together with the Court of Appeal, I think there is room for you to increase the number of judicial associates. If there is a big demand and if so many people are showing interest, it is such a good opportunity for people to learn and also to know the most updated situation. I think there is room for you to expand the scheme, isn't there? Ms. Lau, thank you for the question. Mr. Kwok, you will know that in the past few years, we have been expanding these schemes. In fact, we have a plan to review the operational need. Right now, we intend to recruit again in 2019. Any follow-up? Can you not increase the quota? Thank you, Chair. Our view is, yes, there is room for reviewing the number. In other words, there will be an increase. We'll actively consider that. We are still reviewing the operational need. Initially, we think that we can increase the number. Thank you. I'd like to declare first that I work in the law faculty of the City University. I teach law there. So I do understand what Mr. Paul Mitchard is saying. First of all, it seems there is not enough publicity. And I'm talking about the transparency of selection. After a student has read PCLL, well, not everyone knows that this will be one way to start a career. So what has happened? What is your policy? This is my first question. Secondly, how many years have we had these schemes? And law graduates who have been judicial assistants or judicial associates, how many of them have eventually joined the judiciary? Do you have the figures? Maybe these schemes are too new for you to give us figures, because in the US, if you have been judicial assistants or associates, first of all, these must be the top graduates of law. And secondly, I know that the majority of the heads of law departments started as law assistants, judicial assistants, and some of my students have become judicial assistants, and they had a first honor upon graduation. So they are really the top students. So I'm talking about whether you receive recommendations or you get nominations or you just do open recruitment. And every year, I believe there are quite a number of first honor students from the 3 schools of law. Not every one of them wants to become a judicial assistant, but this will allow them to understand judicial work. And they only have 1-year contract. I'd like to know whether they are paid reasonably in that year. Judicial Administrator? Thank you, Chair. As I said, every year when we do recruitment, we advertise online and in newspapers. We also write to the 3 schools of law. In that letter, we attach all the details of the scheme, and we hope the schools of law will disseminate the information to the graduates of that year. Chairman, I do agree with you in saying that we do attract many top-notch students. When we do this selection, it is up to judges to form a selection panel, and we conduct interviews in order to take on board the best ones. And, Chairman, you said that a number of years has passed. How many eventually joined the judiciary? I think it's premature to talk about this because, as we said in the paper, with regard to substantive appointments, judges should have certain years of practicing experience, and the lowest requirement will be for magistrates, which is 5 years, district court judges 5 years, and then high court judges 10 years. However, in actuality, those who have actually been appointed as judges and judicial officers, they go way beyond that minimum statutory requirement. At magistracies, 14 years, and then district courts, 18 years, and high court, 25 years. But we only have judicial assistants who have been with us for just a number of years. So, Chairman, we may wait and may have to wait for some time before we can answer your question. Indeed, the scheme on judicial assistance has just started for 8 years. So we need to give it some time. What about the salary? Can I defer to my colleague, Mrs. Connie Ngan? We think the salary is very reasonable. This year, for judicial assistance, for CFA, it is $62,612. So you think you can attract the top-notch students, right? Well, to our understanding, this is a very attractive salary. And as we have been saying, Chairman, if there is an opportunity to work at the CFA and to become a judicial assistant there, in fact, it is very good experience. Maybe later you can give me the figures, and that is, after working as judicial assistants, do they enjoy an advantage in seeking a job outside, whether they become solicitors or barristers? Can you keep a register of the numbers for, say, 5 years, 10 years? So we can see better the contribution of this scheme. Do you track down the future career? Say they work with you for a year and they are still very young, and then what happens? Chairman, from what we know, they will practice after working for a year. The majority of them practice. Are they barristers or solicitors? I believe the majority become barristers. But I need to go back and collate the information. But we believe there are more barristers. Mr. Junius Ho? Thank you, Chairman. I don't really understand the system. According to Article 92 of the Basic Law, in order to be JJOs, you need to comply with certain requirements. Magistrates 5 years, district court 5 years, and then high court 10 years. But that has always been the case. But then I'm confused because the paper talks about helping students to start their career, where students can become judicial assistants, and the salary sounds really nice, over 60,000. And the basic requirements are LLB and PCLL graduates. They are not lawyers as such, but they work as judicial assistants to help the Court of Final Appeal judges and High Court judges to do research. To me, that's something quite separate. And then in the paper, 17, para 17, you have a judicial institute. And you also have the executive body. I don't really understand this. Are you training up people here? Apart from recruiting from outside, does it mean the judiciary itself is going to provide training internally? Where did we have our judges? They were from the public prosecution unit, and also you said you also recruited openly.
So legal.
And now you're saying these people who are serving as judicial assistants with an LLB degree, they are also working in the prosecution unit. But on the other hand, there is another channel in the form of a judicial institute. How does that all fit in? I don't understand, actually. Can you please clarify? Well, thank you, Mr. Ho, for the question. We're actually talking about a few completely independent channels. Now, just now, we were talking about, according to Article 92 of the Basic Law, the appointment of judges and also the minimum number of years of legal practice. So that is one system, if you will. And because a panel wanted us to also explain whether we employ other legal practitioners in the judiciary, therefore we have provided further information on other systems, namely judicial assistants and judicial associates. For judicial assistants, they assist in the Court of Final Appeal. We call them JDAs, these judicial assistants. Yes, all they need to have is the LB and the PCLL, and they come in for 1 year. With 1 year's working experience, they leave the Court of Final Appeal, and then they go on to their own professional path. And we will want to look at what they work in after leaving the Court of Final Appeal. Now, after they have gained knowledge on the judiciary, if after many years they're interested to rejoin the judiciary, perhaps that is something that we'll have to look at and observe over a long number of years. So for JDA, for this scheme, it is really designed for this type of students. Now, we have another scheme, which is the judicial associates for the High Court. These are practitioners with a few years of practice experience, and they come in to help the High Court judges to do research and also to handle some of the cases. But they're not members of the judiciary. They assist the judges, rather, of the High Court in their work. As for the Judicial Institute, it is separate altogether, and it is established inside the judiciary to provide support to the JJOs at all levels of court on matters relating to judicial training. Very often, the judges will have to participate in the training themselves. They will have to do the training, but they are busy people. They have a lot of work, and they would need some people with professional knowledge to help them, for example, in organizing training, in providing content, in drafting guidelines or documents, manuals, etc. So there would be such positions for lawyers in the Judicial Institute, and we would recruit lawyers to help the judges in providing judicial training. I hope I'm able to segregate the three and also explain to you clearly. Now I get it, but it is not clear from your paper. Perhaps, Emma, can you please perhaps draw up a chart so that people would know what this is all about? Because when I look at judicial assistant and then I see there are judicial associates, I never knew that there's judicial associates positions. And there is this distinction between the two. Would you please draw up a chart so people would know very clearly? Thank you very much for the suggestion from Mr. Ho. All right, this is a second round of follow-up questions. Something related to Mr. Ho's question. My question is as follows. Concerning the pay for judicial assistants, and for judicial associates, is there any difference in their pay, please? For judicial associates, helping the High Court judges, these are practitioners. These are actually practicing lawyers. Would their pay be higher? They're helping the High Court judges in their work. Would this be actually secondment, that is suspension from their own law firm before they can take up this judicial associate's work? I want to know whether this is, for instance, a full-time job. Thank you, Chair. For the High Court judicial associates, they will need to have practice experience. And in joining the scheme, first of all, they have to go through an open recruitment, and this is full-time work. And we have an employment contract signed with them to be judicial associates for the High Court. And at that point, they will have to cease work with their original law firm. So they will be working full-time as judicial associates for the High Court. As for the pay, Mrs. Ngan will have the information. Yes, we mentioned for judicial assistants is 62,200. As for judicial associates, for civil and criminal appeals, because we request experience, therefore it would fetch a higher pay. I'm looking at the 2018 recruitment for civil work taken up by judicial associates, depending on the point of joining, the number of practice, the number of years of practice. If it's longer, their pay would be higher. So it is according to the pay. It would range from 68,000 to 82,000 plus. As for criminal appeals, it would range from 64,000 to 82,400. So that would depend on the number of years of experience of the entrant. Now, for the CFA judicial assistants, the pay compared to the pay of the judicial associates for the High Court. But let's say, I don't know whether they've just been called to the bar for these judicial associates, if they have 5 years of practice, and if you can give us more information after the meeting, how much experience they have. Perhaps these are professionals who would want to know more about the judiciary work, and they want to consider whether they want to join the judiciary at some future point in time. So therefore, I wanted to know how many of these judicial associates actually join the judiciary after some years of joining as judicial associates. So my question is, do you look for that kind of interest, or are you just looking for an assistant? I note that the pay between the two schemes are almost the same. I mean, of course, it's very attractive as a first job for a fresh graduate to join as judicial assistant for the CFA because the pay is very relatively attractive, and I do not know whom you recruit into your scheme, perhaps first on students or very outstanding students. But on the other hand, I do note that the two schemes fetch more or less the same pay. For High Court judicial associates, their pay depend on the number of years of practice that they've had, even though the starting point of pay is more or less the same as the judicial assistants for CFA, but really depending on the number of years of service in the legal practice of this entrant, we look at that experience as well in setting the pay. We will set a 80,000 plus starting point for judicial associates with more experience. How long has this been in place for, this scheme for High Court? About 3 to 4 years. It started 2015. We've done 2 rounds of recruitment, and this will be ongoing. Well, I remember we've asked this question before. It is not true that all of them would join the judiciary. This is but a job. I understand that. But on the other hand, if they have this exposure to the judiciary and judiciary work, then from day one of recruitment, would you not want to attract more talents who would be interested in the judiciary at some future point in time, because they are being exposed in close quarters to judiciary work? You want to attract these people, don't you? Thank you, Chair. For these High Court judicial associates, every time we have an open recruitment for these posts, if they meet the minimum requirement for joining, then internally the High Court judges, they actually form a selection panel to conduct interviews to see whether these applicants are suitable for the work. If they think that these applicants are suitable for the work of judicial associates, they would extend the employment to them. So there is a selection and recruitment exercise. I totally understand that. I mean, this is different from the judicial assistance of CFA work. I mean, this is 1 year only for judicial assistants, but for judicial associates, it can go on for multiple years. Is that true? Yes, indeed, Chair, that is true. From our experience, some judicial associates, after completing one contract, they feel that they may want to go back to legal practice, and they go back to legal practice, or some would opt to continue with serving the High Court. So it can continue. All right. This will be the last question. There are no other members who would want to ask a question. It is a rare opportunity that we have the two of you here. For the Judicial Institute, you provide all kinds of judicial training. First of all, the trainers, you mentioned just now that these are legal practitioners. Would there be professors, law professors as well? And there are international law that we practice. Would there be international legal persons? And how do they provide the training? It says here that for first employment, it is 3 years. But for us in the teaching profession, we would understand that because the judiciary or the Judicial Institute is not a university, you will not be able to retain all that many teachers or trainers. So what is the remuneration for them? And may I ask, and also for the Judicial Institute, is there a work report so that we know how the judicial training is being conducted for the JJOs? Let's say for artificial intelligence, is that being included in your training, etc.? I mean, we are concerned about JJO's judicial training. And what kind of level of JJOs are being trained by you? Well, first of all, for the Judicial Institute, for these trainers, they are not the professional staff for the executive body of the Judicial Institute. They support the trainers, who are mostly judges, in the teaching at the Judicial Institutes. Because the judges are very busy people, in providing and conducting the training, they will need support from legal professionals who have legal knowledge. And not only that, but also to make the training more effective. So where there is experience with training, the judges would need that kind of support. Now, for lawyers, because they have the legal knowledge, but at the same time, we would want people to have knowledge in training and also in the production and updating of manuals.
Therefore, there are a special type of professionals providing support to our judges. That is the first point for clarification. Secondly, when we conduct training, actually, we do a very diversified job. Sometimes it is done by our judges themselves. Sometimes we invite experts from outside Hong Kong to provide talks or even conduct workshops and seminars with our judges. So we do it in different ways. Now, as to how we should plan the courses and implement training, a lot of work has to go into that. Therefore, in the executive structure of the Judicial Institute, we have people who have lawyers training and also people who have had training experience to help our judges. Thank you. Mr. Junius Ho would like to have a second round. Well, I'd like to follow up on your question. Chairman, well, I've just seen this Judicial Institute. It is a kind of academy within the judiciary in order to allow judges to do even better. So who should be teaching, who should be training? I think this is like a school where there are teachers. And you said you might invite people from outside to have an exchange of views. These people may be really outstanding judges. And also, those people in the institute will be able to assist judges in writing guidelines, not to write judgments, of course, but operationally they can assist judges. But what is the syllabus? I think this is quite interesting. And how does the Judicial Institute benchmark the training? Since you provide training, so how do you benchmark the results? We understand judges will not be compelled to retire because they have life tenure. Are judges joining training voluntarily or mandatorily? As lawyers, you know, we have to go for continuous professional development every year and we need to earn points. So I'd like to know how this institute functions. I was asking about the syllabus because I don't know it. Do you have any literature that I can look at to understand the institute better, Ms. Lau? Well, you can continue to speak. I overran and because I thought nobody was going to ask another question. So please just continue. Sure. I can say briefly that the institute provides a whole array of training. Every year, the institute plans activities and participates in activities, and this is listed in our annual report. I can give you one example. If, say, for example, we think case management is an important area for improvement for JJOs, the Institute will organize case management workshops. And a few years ago, say, for example, when we had to compose the competition tribunal, which was something new for Hong Kong, the Institute provided a series of training activities, including talks, workshops, and seminars. So we provided different kinds of training. And lastly, I'd like to say briefly that judges do spend time on training, and we have adopted a concept where when JJOs are to attend training, we would provide protected time, meaning that within their work schedule, we would assign certain time whereby they can attend training and without having to hear cases. So JJOs will have enough time and space to receive continuous training. Well, okay, I'd like to draw a summary of our discussion. I believe members are quite interested in the operation of the Institute. We don't know much about it. As I was saying, whether you would invite professors from the schools of law to talk at the Institute, and would there be reports? And also, when you ask people to talk at the Institute, would there be remuneration? Because we are talking about the use of public money, and also whether the Institute is really covering all the areas. And because we don't know. Ms. Lau, you said that you might invite renowned people to talk on a particular topic on an ad hoc basis. Can you give a reply now, or do you need time to collect the information? Chairman, as I said, the training activities organized by the Institute or attended by it are listed in detail in the annual report of the judiciary. We'll continue to do that. And I think it's worth mentioning that the Institute is a new organ in the judiciary. At the beginning, well, actually, it was only this year that we were able to engage more professionals. And now we expect the Institute to expand its scope of work in the coming year. We understand your concerns. We'll continue to try to develop new areas for the Institute. We'll continue to look for areas of work of the Institute in order to assist judges. Well, if you already have your annual report, then perhaps you can give us the information. Well, the annual report is published. Mr. Ho would like to say something? Well, following up on what you said, the AI court. I don't know about the application of e-court in Hong Kong. I think we have stagnated in this area. We said that we were overtaken by Singapore. They have electronic filing systems. I think they have been using it for 10 years. We were enthusiastic about it, but it ended with a whim. And that was 10 years ago. Administrator, how can we modernize our Jurassic court system? When we train new judges, perhaps we should allow them to use an electronic platform. I could see instant transcription at Beijing courts. and it saves a lot of time. And they also have e-court. People can take depositions electronically. I think we need to work hard on this front. Will the Judicial Institute devote a certain chapter on modernizing the thinking of our judges? Thank you, Mr. Ho. I think everybody we will meet after the new year. We thank Ms. La. Chairman, may I please say a word? Certainly. Well, actually, we are working very actively on IT. And I may say that we would like to introduce more electronic services. We are amending the rules. We hope that in 2019 we can come to the panel to consult members on the launching of wider e-court services. We are going to have to amend the rules and regulations. I hope members will support us and give your comments. Okay, that's it. Happy New Year. Thank you very much. Thank you, Mr. Ho, for staying till the end. Thank you.